welcome to tonight's webinar. My name is Beth Marsh, and I am the Director of Membership for the Organization of American Historians. Thank you for joining us for tonight's Future of the Past webinar, which is part of a series that explores our diverse history to inform our future. For those of you who have not joined us before, the OAH is the largest professional society dedicated to the teaching and study of American history. The mission of the organization is to promote excellence in the scholarship, teaching, and presentation of American history, and to encourage wide discussion of historical questions and the equitable treatment of all practitioners of history. The Organization of American Historians is located on the campus of Indiana University, Bloomington. We wish to acknowledge and honor the indigenous communities native to this region and recognize that Indiana University Bloomington is built on indigenous homelands and resources. We recognize the Miami, Delaware, Potawatomi, and Shawnee people as past, present, and future caretakers of this land. Tonight's webinar is being recorded, and the recording will be posted on the OAH's YouTube channel early next week. If you have questions, please use the Q&A feature. If you need assistance during the webinar, please chat me using the chat feature. At this time, I would like to introduce our three panelists for the evening. First, we have Holly Brewer, who is the Burke Professor of American History at the University of Maryland. She is the author of By Birth or Consent, Children, Law, and the Anglo-American Revolution in Authority, which won 3 national prizes in legal history, as well as the prize-winning Entailing Aristocracy in Colonial Virginia in the William and Mary Quarterly, and Creating a Common Law of Slavery for England and its New World Empire in the Law and History Review. She is currently finishing a book on the ideological origins of slavery in early America and the British Empire, for which she received a Guggenheim Fellowship. She has contributed to numerous amicus briefs before the Supreme Court and was the lead author for the historian's brief in Trump versus the United States. Michael J. Klarman is the Charles Warren Professor of Legal History at Harvard Law School. His work touches on the Supreme Court and race, the legal struggle for same-sex marriage, and the making of the American Constitution. And he is currently writing a book on race and sports in American history. His other works include The Farmer's Coup, The Making of the U.S. Constitution, From the Closet to the Altar, Courts, Backlash, and the Struggle for Same-Sex Marriage, and From Jim Crow to Civil Rights, The Supreme Court and the Struggle for Racial Equality, which won the Bancroft Prize. He has also won numerous awards for his scholarship in constitutional law and constitutional history. Our third panelist this evening is Donna Schuele. She is a faculty member at California State University, Los Angeles. She holds a JD and a PhD in jurisprudence and social policy from the law school at the University of California, Berkeley, and she has clerked on the Ninth Circuit for the Honorable Alfred T. Goodwin and the Bankruptcy Court in the Central District of California. She is the former director of the California Supreme Court Historical Society and is currently serving as the interim editor of the Southern California Quarterly. She is probably proudest of her IMDb listing, having appeared on numerous episodes of the genealogy show, Who Do You Think You Are? With that, I'm going to turn it over to our host for this evening, Holly. Thank you and welcome, everyone.
Hi, everyone. Welcome. I'm so glad that you could join us here this evening. And we have a few questions to start off, but we're also hoping that you all contribute questions to the chat. So be thinking of questions as you listen to us discuss some of these issues. So the first question for today is, why has history become so much more important to the current Supreme Court?
We negotiated and decided I would take the first shot at that. The conservative justices on the court have articulated a methodology of interpretation. So, for example, with regard to rights, their view is you look at the text of the Constitution, If you're trying to figure out, for example, what the due process clause means or the cruel and unusual punishment clause, you look at the text. If the text is ambiguous, you try to recover the original understanding, meaning what did those words mean to the people who ratified them. But in addition, you can look at history and tradition, and that has two different functions. One is if the history is post-ratification, but relatively near to the time, then the way that the Congress, for example, the first Congress legislated might give you some view about what they thought the word due process or the words cruel and unusual punishment meant. So that's a way of elaborating on what the original understanding means. But there's another way in which they use history and tradition, which is even apart from the text and its original understanding, their view seems to be if a certain right existed in history for a substantial period of time and consistently was recognized, that that might be part of the Constitution as the court should interpret it. So, for example, there's nothing in the Constitution about a right of parents to raise their own children, but if the government passed a law trying to socialize the raising of children, you could easily imagine that the justices on the court might say that violates a constitutional right. Now, the liberal justices, the justices appointed by Democratic presidents, would not argue that history and tradition has no function, but they would argue it has a limited function, and they would argue in favor of the idea that the Constitution evolves in its meaning over time. So even something that was not traditionally protected, like the right of gay couples to choose their partners or even to get married, that something like that might be protected by the Constitution, even if it's not protected by history and tradition. The main criticism of history and tradition as a dominant methodology is that we have a lot of nasty traditions and we excluded a lot of people from participating in the formation of traditions. So, without meaning to denigrate the country in any sense, we have a history of white supremacy. We have a history of married women being treated as the property of their husbands. We have a history of heteronormativity and severe oppression towards gays and lesbians. So if the only rights that can be recognized by the court are rights that come out of history and tradition, this is going to be a pretty one-sided enterprise. It's going to be something that nobody on the left of the political spectrum would agree to sign on to. The conservatives would say in response, trying to make the best argument, they would say a couple things. They would say at least history and tradition has some discoverable meaning as opposed to judges just making things up. And they would also say, if you don't like the rights that are given by the text or history and tradition, you're always free to amend the Constitution. I don't think those are, fully satisfactory answers, but that's what they would say in response to the criticism.
Thanks so much, Michael. Donna?
And I think it should be noted that there's a certain seductiveness to this reaching for what scholars call originalism or original intent, this idea that there's an original meaning that can be discovered. And the seductiveness is this sense, as I think that Michael alluded to, that it is it's discoverable, it's concrete, it's objective, right? And so the those who have adopted a view of the Constitution that sees it as a more flexible document, which we've denoted living constitutionalism, get vilified for judges basically who adopt that role of making it up. And we have a problem with that if we see a court as being different from a legislature, and I think that maybe we'll get to that discussion a little bit later. I think that it's also worth noting, since we are in a setting of a professional historian setting, that this original intent analysis is inherently has been set up to be a historical inquiry. And yet the people that engage in it are not trained historians, right? If you go and look at the law clerks that the justices hire, I don't know that I've never seen a call for historians for newly minted PhDs to be signing up for that job. So that sort of gives lie to what the enterprise is with originalism, and as well. If we're baking in an inflexibility to the Constitution, which perhaps the originalist enterprise might do, then you can ask the question of, has the nation been able to survive for over 200 years because the Constitution has been treated in a more flexible way, that it has not been treated as a brittle document? And if that's the case, then then one might even say that there's a danger with originalism. But I find it very interesting that the latest appointee to the court, Ketanji Brown Jackson, seems to have seen the conservatives' originalism and raised them a few dollars. She really has, I think, exhibited a geniusness in wading into those waters and calling for a different historical analysis than the conservative justices have.
And I would just add to this, or just to make a few connections, what Michael was talking about in terms of how the conservatives on the court, in particular, are using history, is often called originalism, just to connect to Donna's comments. And I also wanted to add, it's not only that the court, so many of the justices on the Supreme Court aren't trained in history and don't have good access to historical sources, it's that sometimes it seems like they aren't exactly engaging in the history in good faith, or they're only understanding a small part of the history. So to turn to Michael's comment about the role of parents in raising children and those kinds of questions, there's a large body of common law sources about that that existed at the time that the Constitution was written, that aren't necessarily written into statutes. And if you don't have a sense of how all of these work together, the written Constitution, the statute law on the federal level, and the existing common law, which they often didn't think they needed to legislate about, you can come up with a really kind of hollow understanding. But it does sometimes seem to me, through that drawing on a long tradition, they're often using the past to make a future. And even in the 17th century, they were doing that. So the main person writing the charters for the New World, a man named Sir Henry Spelman in the 1620s, was actually searching through ancient medieval records in England to look for examples that he could use to write some of these charters. And Jefferson, at the time of the Revolution, was talking about ancient Anglo-Saxon pre-Norman conquest law as a sort of basis of rights. And so it's crazy how the past can be used to actually create change. And there's a sense in which the current Supreme Court sometimes does that. Okay, second question. Are there any cases that you think are particularly striking in their use of history, or in fact their avoidance of history? Donna, you want to start this one?
Well, I think that there's, certainly people most immediately will point to the Dobbs decision and this, in many ways, rather strange use of history by Justice Alito. But in comparison, if you go back to Roe v. Wade, Justice Blackmun relied on, it was a different history, but also relied on history to reach the decision in that case, that I don't know that we can, if we're getting into the weeds here, that case established a woman's right. I think that was worked out in subsequent cases, because in many ways, the way Blackmun wrote that decision and called on the history, it was a physician's right to treat one's patient as one saw fit. And physicians were seen as being in the early 1970s as mostly being male, right? And so it's interesting to see those two uses of history, but then to ask whether that ought to be determinative of the establishment, the existence or non-existence or the scope of a right, and whether it's a fundamental right. I have to say, I did not really find in Roe v. Wade the discussion of history to be, all that relevant. And interestingly, when Blackmun got to the point of asserting the right, that's pretty much what he did. He went from, one sentence to another where you can see a chasm, a reasoning chasm in there, but he just jumps right into asserting the right. And with this history sort of being as background, and perhaps one might argue that partly because Blackmun relied on history the way he did in Roe v. Wade, that leads Alito to try to swat that history down and replace it with another history, right? Where maybe the historical inquiry is really not all that relevant to the issue, except for the fact that the court in precedent has said that one way to determine if something is a fundamental right is to look at the history and tradition. But it's not something that the court does consistently, as Mike has pointed out. And at the end of the day, when you're looking at sort of a larger body of cases, it kind of looks like they go to history when it suits them and not when it doesn't, and that we're left with a very results-oriented jurisprudence. I think the Second Amendment cases are another area where the use of history is a very interesting but perhaps different one. Mike, let me kick this over to you.
Well, I'll just start by reaffirming what you said, which is they seem to pick and choose. They're inconsistent, maybe opportunistic, if you want to be really critical, a little hypocritical, because they invoke history when it suits their purposes and they don't when it doesn't. Dred Scott's one of the first cases that invokes almost a modern notion of originalism. So Chief Justice Taney says Black people, even if born free, can't be citizens of the United States. And he says, don't blame me if you don't like that. I don't criticize me as being racist. It's the framers, the people who wrote the Constitution, never would have imagined that Black people, even if born free, could be citizens. It's an originalist decision. It's kind of a black eye on originalism. Even then, Taney's history, not to say that he's wrong, but he only paints one side of the picture. There are arguments that he's wrong on the history. There's arguments in defense of him, but it's another example that you can look out at the crowd of historical episodes and find friends and adversaries. I'll take a couple examples, and I won't talk about Roe because Donna already did. She started to mention the Second Amendment as a good example. So for most of American history, it was not assumed that the Second Amendment protected an individual right to keep and bear arms. Indeed, in the 1930s, the Supreme Court, in kind of a throwaway line, said it's not an individual right to keep and bear arms. It's a state right to maintain a militia against the federal government. Almost all the U.S. Court of Appeals followed that. And then the Supreme Court in 2008, after a 50-year campaign by the NRA, said, no, we think that's wrong. We think it is actually an individual right. That's the Heller case from the District of Columbia. It was an ideologically divided court. Most historians think that the four dissenters got the better of the argument, although, again, it's not that no case can be made. It's just that it's not the most persuasive case. What's really interesting with the Second Amendment is that they come up with a whole new methodology for defining rights in the Brewing case. That's the New York case from 2022. And they say, we're not going to treat this like other rights where we say if there's a right involved, we do a balance. And if the right's really important, then the government has to show a compelling interest if they want to intrude on the right, and they have to show the means are necessary to accomplishing that important interest. Justice Thomas writes an opinion and says, nope, that's not the methodology. The methodology is if you want to regulate guns in any way, you have to show there's an historical tradition in regulating them. Now, there's a whole bunch to object to in that formulation. The framers were dealing with a society that was 90 to 95% rural. You were dealing with breech loading muskets. You were not dealing with machine guns and high-powered magazines, rifles, semi-automatic rifles. But even leaving that aside, they immediately abandoned that methodology this term because they were dealing with the question of whether somebody who had a protective order against them and had repeatedly abused women with whom he was in a relationship and had fired a gun off in public, whether that person could be denied access to a firearm. And there is no history and tradition of denying firearms to people with protective orders because traditionally we didn't care about that. We just, traditionally, the husband had a right to abuse their wife, and which is another argument for why history and tradition should not be defining the scope of rights. But the point I'm making is they adopted a methodology based on history and tradition, and then most of the court rejected that methodology because the result was too disgusting for them to stomach. So, I give them some credit for saying that people who had protective orders shouldn't be armed with rifles and handguns, but the only way they could get that result was by ignoring their own methodology. The other area I would just mention briefly is affirmative action. So, you can't have the constitutional invalidation of affirmative action and consider yourself an originalist or a traditionalist. The people who wrote the 14th Amendment were ironically too racist to be colorblind. They did believe that African Americans should be protected in civil rights, but they had no problem with school segregation. They had no problem with excluding blacks from the ballot. They had no problem with excluding blacks from jury service. And they certainly had no problem with barring interracial marriage. So the idea that the Constitution is colorblind is absolutely a made-up idea. It's not grounded in text. It's not grounded in original understanding. It's not grounded in history and tradition because we have a history and tradition of white supremacy, state-mandated segregation, all sorts of methods to disfranchise blacks and so forth and so on. So, I understand that conservatives think that it's repulsive for the government to taking race into account, but it's not banned by the sources of constitutional adjudication that they purport to be committed to. So what do? They pretty much just ignore the history. If you go back and read the SFFA opinion, the Harvard case, the North Carolina case from the term before this one, they just pretty much glide over the original understanding of the 14th Amendment, and they just pretend that we've always had this presumptive ban on color consciousness, and it's just invented pretty much out of whole cloth. And, they're free to read that into the Constitution if they want to, but then they can't really purport to be committed to these very narrowly defined methodologies of interpretation,
So I'll just add to
as
that.
Justice Jackson pointed out in her dissent.
Yeah, exactly. I add to that. I do think that we have a complex history, and his history of arguing over questions of equality under the law, which you can see even in the Declaration of Independence. But actually, I do want to disagree with you a little bit about, in fact, about the Rahimi case. So I was contributed to an amicus brief in the Rahimi case. And one of the problems with the original decision in Bruin was it pointed only to statutes in terms of understanding what the law was in practice. But in fact, there was a common law, a tradition of whereby wives, for example, could claim protections of the peace, sureties of the peace. And there are examples, and you can read about it in Guides for Justice of the Peace, for example. And there are examples of weapons being removed in some of those cases. So we actually highlighted that in our brief, and the Supreme Court majority 8-1 did actually cite that portion of our brief. So it may be just because they wanted to, because this was a horrific case, because Rahimi had actually shot at his ex-girlfriend. And so, but there, we could find a history and tradition that they could latch on to. But that also gets to this crazy issue of what does it mean if you just look at statutes and ignore the common law?
And I'd like to get back to Mike's discussion a bit of what we've come to call conservative color blindness, right? And again, that there's this certain seductiveness to this if you're sort of speaking to the public or signaling to the public on this, that I think you can look at the civil rights tradition and Martin Luther King's positions and speeches and so on, and the Brown v. Board decision, which Mike, you could talk much more at length about that than I, that there is this easy way to take that and sort of pull it out of its context of the time and into a current context and sort of shape this color blindness narrative around that 1950s, 1960s civil rights movement, process that then sounds very, I think, like I said, it sounds seductive to, to people that are sort of dialing in. And if you look at the Brown decision, right, one of the criticisms of the Brown decision, probably the main criticism of it, is that Earl Warren writes this decision that is not really grounded in precedent or grounded in doctrine. There was an attempt to give an originalist analysis, right? They sent it back for briefing on whether, what was the state of school segregation or non-segregation at the time that the 14th Amendment was drafted. And the easy answer was that there wasn't much of a tradition of public schools yet, right? So that whole, if Warren thought that was going to give him an easy out, it didn't happen. It didn't materialize into anything. And so, so I think that there's, one has to be able to take a more sophisticated view of the times in which Brown was decided and in which the civil rights movement was growing in the 50s into the 60s to really understand what was going on there, to really make an argument against this conservative color blindness. But it takes a lot of nuance, and you can't do it in a 30-second soundbite.
I would just add briefly that one case where the majority on the court ignored most of the history is U.S. v. Trump, the major case involving presidential immunity. And there, only the liberal justices actually engaged the founding era constitutional history, which was solidly against immunity. I know I did a lot of the research on that and working with others, but a lot of the writing in January and February of this year. And I was pretty comprehensive in reaching out, talking to so many people, the editor of the documentary history of the ratification, just making sure we have the whole picture, laying out the history, and the conservative justices in the court, the majority, ignored all of the history, and they kept citing a 1983 civil law case called Nixon v. Fitzgerald as the basis for their decision and ignoring the longer past. So that to me was so striking from a majority a set of justices who claim they really care about originalism, really ignoring it in this case. Okay, we have a couple, I do have one more question here, but we have some questions from the audience, so I'm gonna read one of those. I mean, first of all, I wanted to note James Banner pointing our attention to Jonathan Gienop's forthcoming book Against Historical Originalism, which I too am very excited about. I've read an earlier version or parts of an earlier version, and it's a terrific book. But the first real question is about whether in US history there's ever been such a fever pitch over upholding the integrity of the Constitution as during this current presidential election cycle. Michael, you want to start with that one? Or?
We are, sorry, that's my dog in the background. We are facing a constitutional and democratic crisis unlike anything we've seen since the eve of the Civil War. The country is as polarized politically as it has been since the South seceded upon Lincoln's election, and we have a has said he would terminate the Constitution, has said he would be a dictator from day one. We have a Supreme Court that invented a criminal immunity that, as Holly was suggesting, is not the original understanding. I would go even further. I'd say in terms of history and tradition, for almost the entirety of the American Republic, it was assumed that the President of the United States could be criminally prosecuted.
Yep.
There was a big debate over whether he could be indicted and prosecuted during his presidency. That's never been conclusively resolved, but most people think not. But the flip side of that, the other side, was that, of course, he can be criminally prosecuted after he leaves office. That's why Gerald Ford pardoned Richard Nixon, because the assumption was he could be prosecuted after he left office. So we have one wing of a major political party that is prepared to tear up the norms, support a candidate who has threatened violence, bloodshed. There'll be blood in the streets if he loses. He is committed to firing 50,000 civil servants. He has said he would use the Justice Department to go after his political adversaries and shut down media companies. He's talking about invoking the Insurrection Act and using the military to suppress civil protest. Yes, I think we've never had this sort of crisis since the Civil War. And in some ways, it's kind of interesting. When Southerners walked out of the Union, they didn't think that they were trashing the Constitution. They actually believed they had a constitutional right to secede. Now, they lost. If they'd won the war, then maybe they would have had a constitutional right, as the Supreme Court put it in the 1870s. But they had at least a plausible claim that the Constitution was on their side. I can't think of any time in American history that people were openly advocating trashing the Constitution. So I think this is pretty much unprecedented.
There's and there's another sense too of where are the guardrails, right? And that perhaps 4 to 8 years ago we thought that the guardrails included the Constitution, and that one of the things that we're seeing is that there are it's a very short document in terms of its text, right? And there's a lot of holes in there that over the centuries have been filled, as Mike noted, by norms. And when the norms are working and everything's firing in all cylinders, we don't really notice that it's norms that are governing us, and it's norms that are providing the guardrails, not this sort of more established textual document, right? And we're seeing those norms being trashed with nothing really that can be done about it, unless one replaces the norms with law, right? And when norms work, we tend not to go to law, because why bother going to that formality, right? And so, but part of the perfect storm right now is not just that we're seeing the norms being torn up, but that the other parts of the guardrail, particularly the legislature, Congress, and the executive branch, are either powerless or are acquiescing or actively promoting the ripping up of those norms. So law isn't going to come, So as they say, the cavalry is not going to come to save us, and we know that. So we now, this is kind of laid bare of where the gaps are. I like to use the metaphor of a constitutional fabric when I'm talking about the Constitution and what might be done. And that fabric is woven over many years and decades and centuries, and oftentimes without our really paying too much attention to it, right? And so if we have a court, and this is more in its, sort of case-by-case decision-making, but that pulls out a thread of the fabric, right, of something that's established and pulls that out. Another way to say that is to overrule precedent. At what point does that really cause a problem? because you pull out one thread and you probably don't notice it, right? But there may be a crucial thread that is pulled out, or there may be so many threads that are pulled out that then the fabric just falls apart.
And
And I think pulling out is also those trashing of the norms, that those are woven into the fabric as well.
And I would emphasize that. So as a historian who studies as well the 17th and 18th centuries, as well as the American Revolution and its aftermath, I'm particularly frightened by what I'm seeing right now. And that's because the decision, for example, in Trump v. US echoes the kinds of decisions that were characterized absolutism or authoritarian rule in the 17th century. So that it actually looks like the kinds of decisions the High Court in England was making in cases like Godden versus Godden v. Hales in 1686, which was a case which said the king was above the law and not accountable to it, which was actually crucial to the Glorious Revolution. In fact, amazingly, I mean, in 1688, there was a Glorious Revolution in England that many of you might or might not know about, but the Convention Parliament was obsessed with that case, and actually called in all of the 12 judges of the High Court, that's how many there were at that point, to interrogate them about how that case got decided, and investigating judicial corruption, and fined all of them, and said none of them could ever hold any office. They were that horrified. But it's essentially, it reminds me of cases, the kinds of political structure, legal structure that let kings get completely out of control. So it's taking, although arguably in the 20th century, we've had presidents that are too powerful. It's what some have called an imperial presidency. This takes away so many more of the guardrails. So it reminds me, I mean, the period that I study is a period when there's many what we would call rights being taken away or argued over, or at least taken away temporarily, and we're even getting things, rights like habeas corpus passed into law in 1679 was a huge struggle, which is the right to know what you're charged with and not to be kept in jail without being charged for too long. So as a historian, I'm deeply concerned, because I can see these patterns writ so large in the present, and we seem to be rocketing forward without people really realizing where we're going. Okay, so I'm going to go to another question from the audience. This is regarding the 14th Amendment. So it seems to me, this is the from the audience, it seems to me that it's not hard to argue that the intent of the framers of the 14th Amendment, such as Charles Sumner, had something pretty close to absolute equality in mind. A decade later, the courts began to narrow the intent to the point that a case like Plessy could be decided in a way that would have made Charles Sumner roll over in his grave. So the question is, whose history, the intent or the interpretations a decade and more later? And how can they and do they account for such differences in the current court? I don't know who wants to start.
Mike, you want to start with that one?
Sure. Charles Sumner was a fabulous person. He argued a case in the Massachusetts Supreme Court about 1849, 1850, arguing that school segregation violated the Massachusetts state constitution, which had a provision analogous to the Equal Protection Clause, and he lost. I agree with the premise, absolutely. Charles Sumner would have liked to pretty much reject any race discrimination by the government across the board, probably even to the extent of striking down state laws that barred interracial marriage, certainly laws that didn't allow blacks to serve on juries. The point is that Charles Sumner was not the median voter in the Republican Party. Sumner and Thaddeus Stevens were the two radical leaders who would have liked to confiscate slaveholders' property and redistribute it to slaves, and they would have liked to write something very near to full equality into the law. But the Republican Party had various factions, and the more moderate and conservative factions were afraid to go home to their constituents and tell them, we've written full equality, colorblindness into the law, because the fact of the matter is that the northern states, they almost all, except for 5 states in New England, allowed blacks to vote. Every other state in the North did not allow blacks to vote when the 14th Amendment was being discussed. Most of them either excluded blacks from public education or else segregated them into separate schools. The southern states didn't have public education until after the Civil War, but northern states did, at least for a couple decades, and blacks were only integrated in Massachusetts and northern New England. Most northern states did not allow blacks to serve on juries, and most states did not allow interracial marriage. And while Charles Sumner and Thaddeus Stevens would have been willing to strike down those laws, Republicans were very nervous about going to their constituents in the 1866 off-year congressional elections and saying, we wrote into law black suffrage and black jury service and a ban on school segregation. They were not prepared to do that. They thought they would jeopardize their supermajority in Congress. By the 1890s, I'm making the argument that Plessy versus Ferguson, that upheld school segregation, was not consistent with the original understanding. But again, I agree with the idea that Charles Sumner would have been rolling over in his grave at Plessy, and the country had become dramatically more conservative on race issues. So the generation of abolitionists had passed away. The Republican Party was no longer interested in winning the votes of Southern blacks because they had secure control of the national government because of shifts taking place in the Northern electorate. The country was becoming more sympathetic to racism because of its imperialism, right? It was about to fight a war with Spain, which would result in the Philippines and Puerto Rico becoming part of the United States, and most Americans were not going to give them citizenship, so they were more sympathetic to white Southerners not wanting to give blacks full citizenship. And a factor that was incredibly important, but I think is not as broadly understood, was the mass migrations that were starting from Southern and Eastern Eastern Europe, Italian Catholics, Russian and Polish Jews. And those groups were seen as racially inferior at the time, and the United States was not necessarily willing to give those people full citizenship. And again, that led to a more conservative view about allowing white Southerners to treat blacks. And in 1890s, 90% of blacks still lived in the South, allowing them to restore their own version of home rule, which meant blacks should be disfranchised, notwithstanding the 15th Amendment. And the Supreme Court accommodated that. It not only allowed segregation, it also allowed the Southern states to do the various things they were doing to completely disenfranchise African Americans, despite the fact that the 15th Amendment said you can't do that.
Thank you
And
so
I
much.
think that
Oh, go ahead.
I
I mean,
think that
we don't have not much more time, so
I think that what Mike is also alluding to is this question of whether the court, well, it's not a legislature, and it's not in that sense a popular body, whether it puts its finger to the wind to see which way it's blowing, right? And we were talking about the integrity of the Constitution, but I think we can also talk about sort of the legitimacy of the court, right? And a metaphor that I like to use in that area is sort of the bank account or the ATM. And the court, when it makes a decision that's unpopular, it's drawing down on that bank account. When it makes a decision that's popular, it deposits into that account. But what the court may not know is the degree to which, what is the amount in that account, and what what constitutes an overdrawing of it, right? And so there's this sense, and I think a lot of political scientists and historians have made this argument that the court follows, it doesn't get out ahead of, and that when it does get out ahead of, and one might argue that Roe was a case where it got out ahead of, that there's sort of a backlash or a constricting in afterwards, right? When I think, Mike, you've made the argument that the court may have gotten out ahead of in the Brown decision, right? And this is Gerald Rosenberg's work in The Hollow Hope that he's really looking at, and so and so you can take a look at what's happening in the later 19th century. And I think, Mike, you brought in the really, all these threads of the broader historical argument that the court was following where the people were going on this. And one of the justices on the court in relatively recent history, Sandra Day O'Connor, was lauded for being somebody that, could read the room very well, that she might not have been bound by a judicial ideology, but instead was really cognizant of where the room was on things. And this is a really interesting question of whether the court is, I think there's a lot of agreement, especially among historians and political scientists, that the court is really taxing its legitimacy, that it is drawing down on that bank account, and in a way that we haven't even talked about, which is the ethics issues. And
Well, the ethics issues, and then the incredible number of reversals of precedent in this particular term, in terms of getting rid of the Chevron decision, among many other, and among many others. There's just been almost more than many of us can keep track of. So I would say that Dobbs was even more getting ahead of than Roe, arguably, but we could. But one of the questions from the audience, I just want to answer briefly. This is directly to me, but I'm sure Michael especially might have something to say about it. Do we have a process in the United States whereby judges can be investigated, fined, and fired, as the British case you mentioned? And of course, there's a process of impeaching justices, but it takes a 2/3 majority in the Senate, which has only been tried once and was unsuccessful. And as Jefferson wrote afterwards, is nearly impossible because you can nearly always find 1/3 of the people who are make it difficult to do something like that. But there are active efforts to set in place better judicial restraints. And I have written about and argue that, in fact, we should be more, that the main power left to Congress under the Constitution is to change the size of the court easily. That's not set under the Constitution. And because it's actually really difficult to remove judges, except for if they're actually impeached by this very difficult process, the best way to check the current court, which I think is really moving beyond its remit and essentially using their oversight to create policies rather than just to, check, that would be the appropriate response. Michael, do you have any thoughts about this one?
I guess I just want to stress for people in the audience who don't have a baseline for comparing what's happening today. So think of it as two different baskets of issues. One is Justice Thomas receiving at least $4 million worth of luxury air travel, his mother's house being bought for her, his adopted son's private school tuition being paid for him, at least $4 million, and we're still discovering, or ProPublica is still discovering, new instances. What would be the baseline? How can we decide whether that's corruption, whether that is impeachable? And the answer is there's never been anything like this in American history. The closest case is Abe Fortas, who was forced off the court in 1969. And basically the charge against him was that some friends had put up some money so that he could teach a seminar at maybe American, one of the DC law schools, and get an extra $10,000 in his salary, and that he had some sort of stipend from some wealthy guy who is being investigated by the SEC, but there was no specific allegation of any transgressions, that he had resolved the case, for example, in favor of this guy. So Clarence Thomas is getting $4 million from a wealthy donor who has regular business before the court and has Thomas with various other billionaires together to talk about how terrible government regulation is. And then you've got Sam Alito flying flags outside his house that suggests that he or his wife or both of them are sympathetic to the January 6 people who are trying to prevent the peaceful transfer of power. And the other flag is identified with Christian nationalism and was also flown by some of the January 6 protesters. And the question is, should they be recusing themselves from cases involving the January 6 protesters and whether they can be criminally prosecuted for obstruction of Congress and whether they should be recusing themselves from the case involving Trump's criminal immunity? And the recusal question is not whether you're biased, or not exclusively whether you're biased, but whether a reasonable observer would believe that you're biased. So not only has there never been anything in history like these examples, but they declined to recuse themselves from cases where it would seem pretty obvious that a reasonable person might think that they have a rooting interest in the case. So we have never seen anything like this. And not a single Republican in the Senate has raised even a whimper of concern about this. So impeachment is a joke. It's off the table. If that wasn't clear from the fact that Trump couldn't be impeached and convicted after he incited an insurrection against the government. There is no Republican senator who will remove these people because they are on the Republican side. And this goes to the point that I think Donna was making before. Constitution's just words on a piece of paper. Unless people are inclined to enforce it, unless there's public opinion, unless statespeople will stand up and do their jobs, then it means nothing. So these justices are not going to leave, and it's impossible to impeach and convict because there's a supermajority requirement, and the Republican Party is not going to remove one of their own. So if you want to do something about the court, as Holly said, the only solution that's viable would be to expand the size of the court. I would be happy to make the case for why Democrats should feel entitled to do that. The court's been packed against them. They ought to pack the court in response, but that's not a position that the Democratic Party is prepared to embrace right now.
And I
So
think-
I'm nearly out of time. So I just wanted to read a couple of connected questions, and maybe Donna, you can start, and if you want to add something related to the other one when we're done. So the two questions are, how does the current conservative Supreme Court compare to conservative courts of earlier eras, such as the 1890s, the 1930s, in terms of their resort to history and tradition to justify their positions, or I would just say compare in general? And then another one that's related, there's wonderful questions, and we won't be able to get to all, but this one, when before in US history have sitting Supreme Court justices been so strongly politicized as they are now, where a 6-3 decision along party lines is almost guaranteed? So Donna, you want to say a few words?
Let
Keep
me-
it
yeah, let me-
relatively short, and then Michael.
Yeah, let me jump in a little bit on this. Just a coda on our previous discussion. I think that one of the other sort of norm type forces is this sense that a chief justice is worried about the legacy of the court that bears their name. So the Warren Court, the Roberts Court, right? And one of the things that I think has been shocking in the past few years is that we seem to have a chief justice that doesn't care, maybe has given up. The Affordable Care Act decision seemed to be Robert's vote seemed to be explained by a concern for the for the legacy of that court, which really that seems to go away. So I think there's this real puzzle around Chief Justice Roberts and what he's what he's doing in in all this or not doing. So as far as taking a look back at earlier the historical record around earlier conservative courts, I'd go back to the 1930s and and that's sort of the Four Horsemen Court, the New Deal legislation that is being struck down, Franklin Roosevelt coming up, which ends up to be too clever by half with this court packing plan that gets that label. And once the court started upholding New Deal legislation, I think there's some inclination to look back at that court and to say, you know what, the justices that were invoking a history and tradition that were on the conservative side just saw history in a different way. That there was nothing malevolent about what they were doing, but it's perhaps it's easier for us to tell that history if we're sort of telling a winner's history, right? That we might not look at the court quite that way if it had turned out differently, if that conservative line of reasoning had extended to overturning the Social Security Act, the NLRB, et cetera, what Roosevelt was afraid of. So, I think it's interesting that, it kind of shifts over time in terms of how we look at that. However, I do think in terms of politicization, if you go all the way back to the early court and all of the appointees being necessarily Federalists by Washington, you've got this time that Jefferson thought the court was very politicized.
You did. Okay, Michael, I'm going to give you the last word on this. Go.
So let me try to say a quick word about both questions. In the 1890s, there's this famous trilogy of 1895 where the court guts the Sherman Antitrust Act, strikes down the progressive income tax, and upholds the labor injunction. And that made the court a big issue in the 1896 election. But those are all kind of economic issues, right? Labor disputes, the scope of the antitrust law, and the constitutionality of a progressive income tax. Same thing in the 1930s. The main cases you think of are the National Industrial Recovery Act case, the Agricultural Adjustment Act case, the New York minimum wage case. Those are all issues of economic regulation. Think about what the court does today. You've never had such an imperialist court in the sense that it's hard to imagine a social or political question that won't be resolved by the Supreme Court as a constitutional issue. So just rattle them off very quickly. Affirmative action, abortion, gun control, campaign finance reform, the Muslim travel ban, death penalty, criminal immunity for the president, labor union rights, and I could go on. Everything is a constitutional question that the court will resolve, as opposed to just issues of economic regulation. What would be an analogy? The court, I can't even think of what it would be. The court striking down women's suffrage, the court, striking down white supremacy, the court, the court just didn't control everything in the same way that it does. Now, on the 6-3 party lines, the court's always been political, as I think both of you just suggested. What's changed since the 1950s, 1960s is that the parties didn't break down along ideological lines. There was a conservative and liberal wing in the Democratic Party. There was a conservative and liberal wing in the Republican Party. So when the Warren Court divided 5-4 in a case like Miranda, it often divided 5-4, and they were predictable justices, but there were Democrats and Republicans on both sides. The same thing's actually true in the New Deal. There was a pretty conventional 5-4 split, but the most conservative justice on the court was James McReynolds, who was appointed by Woodrow Wilson. The parties were not ideologically polarized. What's happened in the last 50 years is they're now perfectly polarized, and you no longer have this phenomenon of Republican appointees who seem either not to start out that conservative or to drift to the left. So by the time they quit, Harry Blackmun in 1994 was probably the most liberal justice. By the time Stevens left the court, when Souter left the court, they were the most liberal justices around 2009, 2010. Now you have a perfectly ideologically polarized court where all the Republican appointees are very far to the right and the Democratic appointees are pretty far to the left, although not as far to the left, according to political scientists. And the Republican Party has created, through the Federalist Society, a reliable screening mechanism. So you're not going to get any more mistakes. You're not going to get any more Souters. You're not going to get any more. Even Powell and O'Connor would be regarded as ideological traitors by today's Republican Party. Even Powell wrote the Powell memo, right? He's the one who set the agenda for the Federalist Society and the Koch brothers and the deregulation of everything. Powell would be appalled by today's, MAGA movement. So that's what you have. You've got this extraordinary division. And not only are the parties polarized, but the justices are polarized. And not only are they polarized, but they now gravitate to the extremes, just in the way that the MAGA wing of the party, through gerrymandering, partisan primaries and campaign, right? The end of campaign finance reform, right? That's how you get a situation where the state of Texas passes an abortion law that 20% of the state would vote for, and the Supreme Court will uphold it because the Supreme Court is as ideologically extreme as the wing of the party that now controls the policymaking. So
And
that is an
it's-
unprecedented
which
situation.
is terrifying precisely because the court has now assumed jurisdiction over so many issues. And so the court, the non-elected court, the least democratic branch of the government, the part of the government under the Constitution that has the least space devoted to its role, has now assumed a very large space, a very large place in deciding what American laws and policies should be, much larger than in the past, right? Yeah, okay,
Hard to think
excellent.
of,
We
hard to
are
think
we
of
are
any
actually over
historical
time.
analogy.
We're actually over time. Thank you, everyone, for joining us and for thinking through these complex questions of history and the Supreme Court and the role and how the Supreme Court is using history. And I'm sorry I didn't get to all of your questions, but there were other wonderful ones. And thank you so much to the Beth Marsh and the Organization of American Historians for sponsoring this event. Beth, did you want to say a couple words?
Yes, thank you, Holly. Thank you, Donna. Thank you, Michael. We really appreciate you sharing your evening with us. This was a fabulous conversation. And thank you to everybody who joined us in the audience. Our next Future of the Past webinar will be next month, and it will be on the summer issue of the TAH that just came out, the next installment of the US History at 250. So keep an eye on your inboxes for that information here in the near future. Thank you. Have a wonderful evening, everyone.